mobile with the language.
Please, Lordship. Lordship, I beg to mention item number 2 and 9.
Wait for your
Lordship,
turn. Wait for your turn. We'll pass the order. Lot list is very short. Wait for your turn. Let the matter reach, we'll consider. Yes, you are the public prosecutor? No, Tapin, you are the public prosecutor.
My lord, item number 1.
Just a minute. You read 19 to 24. Please take your seat. Please take your seat. 19 to 24. Read the orders for yourself. Mr. Tapin, you also come forward. You are appearing for the respondents, I believe. Who is appearing for the respondent? The Union of India or what? Union of India. Sorry. No, Government of Arunachal Pradesh. No, you don't have to read it. You just read it because I am asking you to read. That is, there is a reason behind it. Kindly read. Who is appearing for the state? So take your seat. There are reasons. You can take your seat and read. You can take your seat and read. Second. BNS. No, that income, BNS. Very effective
Yes, Lordship.
You have read?
Yes.
What you have found?
Lordship, the condition of the bail, Lordship, the 1 lakh amount is too excessive.
You have not found anything. The case was registered under what provisions?
POCSO, Lordship.
It was registered in the POCSO.
Yes.
Is there anything in the order that while considering the bail of the petitioner and while granting bail of the petitioner, the informant was heard?
No, Lordship.
Whether notice was issued to the informant?
No.
In that circumstances, what should do, state should do?
Yes, as per this, in this coordinated bench, Lordship, the Honorable Chief Justice issued direction to adopt the practice of issuing notice to the victim, Lordship.
Now, what is the law in this regard? If such kind of bail is granted in a POCSO case, issuing notice to the informant and without giving hearing to the informant, what should state do?
Since Lordship, bail was granted on medical ground, Lordship.
Whatever may be the reasons.
Yes.
Ultimately, the interim bail was made absolute.
Yes.
In all the three orders, whether the informant was heard,
No.
then whether that bail is valid or an illegal order.
In fact, it's illegal.
What is the law laid down by the Supreme Court in this case? What should the state do in that case? If such kind of bail is granted,
Yes.
what should state do?
This bill may be cancelled, Lordship.
Who will approach? There are two ways.
Yes, Lordship.
Either court should take it pro moto.
Since I am not aware with this, Lordship.
We do not know. We have brought it to your notice. That's only we know. That is why I asked you to be here. The court has requested the presence of the public prosecutor in this court only for that matter.
Yes.
Now it has been brought to your notice.
Yes, Lordship. Will take necessary.
Mr. Kato, see, basically, we are here. You are there only to assist the court,
My lord.
to execute the matter.
Yes.
Mr. Tapin is there appearing for the government
My lord.
so that the matter is executed judiciously. There is nothing. Now, when we feel that when the lawyers doesn't point out before the court certain aspects of the matter,
My lord.
the law, whoever appears, and the special public prosecutor also is not pointing out before the court, and these orders are passed, it pains.
My lord.
See, we can take tremendous action against all of the persons involved in this matter, the concerned officer, the judicial officer who passed that order, the lawyers who was involved in both the sides. That is why the POCSO Act is something different.
My lord. Exactly. My lord.
It is not just all the provisions like in the IPC or the BNS or something like that. You know why the POCSO court has case as the act has to come into force. There is a reason behind that.
My lord, in the recent judgment.
Whatever may be. While I was going through this order of the concerned judicial officer, I was very sad. At the same time, the petitioner is asking on humanitarian ground for the operation or the medical surgery of his son. But the same person, as of now, the trial is going on. But he's a search-seated accused. He has raped a minor girl. The search-sheet sections are so severe, right? Humanitarian ground for his son is okay, but humanitarian ground for the child who suffered is not there. That's happening. If you read the orders, you will know. You read the communications, you will see what are the sections been search-sheeted with.
My lord.
The trial court itself read that. You go to the judgment of the X versus Rajasthan. You go to the X versus Allahabad. The Honorable Apex Court, how strongly they have passed those orders.
My lord, in this case, my lord, the trial, prolonged trial was, my lord, going
This is
on.
a question of a prolonged trial.
My lord.
Where is the question of prolonged trial?
Now, my lord, after considering the entire aspect, my lord,
That is the reason.
informant,
Without issuing notice to the informant.
my lord, every day,
Granted bail.
informant is, my lord,
Mr. Kato, whether he appears or not, the order of bail granting to the petitioner here itself is illegal. For all you kindly note down the judgment of the Honorable Supreme Court. There is X versus Rajasthan. Justice Particular judgment. Judgment to asani ki tumhara mobile. Tomorrow ready to asani ki sorry. Pen drive for us. Get it. Citation to go there. Kovida hobe manibula ko. Anybody pen drive. And the another judgment is there X versus State of Uttar Pradesh. You should read those judgments. You are the young lawyers. One is X versus Rajasthan that is reported in 2024 0 Supreme SC 1353. Okay, let us proceed with the case. Now you are aware what to do.
Yes. I will take down.
You don't know, up to you. How come the special public prosecutor could consent?
Yes, sir.
Hmm? What kind of special public prosecutor? Heard Mr. M. Katu, counsel appearing for the petitioner. And Mr. T. Tapi, learned senior government advocate, Arunachal Pradesh, for the respondent numbers 1 to 6. On being asked, Mr. Such and such, learned public prosecutor, Arunachal Pradesh, also appeared in this matter. Petitioner, Assistant Commandant, 1st AAP Battalion, Simpu, was arrested on 14/05/2024 in Itanagar Women Police Station case number 20/2024 under section 373 IPC, read with section 6/8/12 of the POCSO Act, read with section 3/4/5/6 of the Immoral Trafficking within bracket Prevention bracket close Act. As he was detained in custody for more than 48 hours, the Chief Secretary of the State of Arunachal Pradesh by order dated 02/06/2024 suspended him from service with effect from the date of his detention, 14/05/2024, directing the petitioner to be at police headquarters at Simphu further directing him not to leave the headquarters without obtaining prior permission from the Chief Secretary of the state. But the said order dated 02/06/2024, the Chief Secretary of the state also allowed the petitioner to draw subsistence allowance as admissible as per existing provisions under FR 53 within bracket 1 within bracket Roman 2 small Roman 2 within bracket small a comma within bracket small b and FR 53 within bracket 2. Inside Itanagar Women PS case number 20/2024. Charge sheet was filed on 26/06/2024. Filed charge sheet number 56/2024. Under sections 120 within bracket capital B /201/323/354/354 within bracket capital A /366 within bracket capital A /370 within bracket capital A /373 /376 within bracket capital A within bracket capital B /506 IPC read with sections 4/6/8/12/17/21 of the POCSO Act, read with sections 3/4/5/6 of the Immoral Trafficking within bracket Prevention Act against the petitioner. And the case is presently pending for trial against him before the Court of Law and Special Judge POCSO, cum Session Judge UPR. During dependency of the said POCSO case against the petitioner, by an order dated 03/10/2024, the Learned Special Judge POCSO UPR on 3/10/2024 in bail application number 344/2024 preferred by the petitioner, granted him bail, interim bail, directing him to surrender before Julie Jail, Itanagar on 28/10/2024. On 28/10/2024, the Learned Special Judge POCSO UPR extended the interim bail of the petitioner dated 03/10/2024 up to 28/11/2024. Subsequently, on 18/01/2025, the Special Judge POCSO made the interim order bail dated 03-10-2024 and 22-10-2024 passed earlier, 28-10-2024. Absolute. Thereafter, the petitioner on 21-01-2025 submitted a representation before the Secretary Home, Arunachal Pradesh, requesting, praying for reinstatement of his reinstatement in service in the post of Assistant Commandant 1st AAP Battalion. And further, sought for RTI information as to when the authorities in the Home Department reviewed his suspension order issued on 02-06-2024. Hence, this writ petition by the petitioner to set aside and quash the impugned suspension order dated 02-06-2024, as in the meanwhile, the respondent authorities did not submit any show cause to him, nor reviewed his suspension order. On perusal of the bail orders dated 03-10-2024, 28-10-2024, 03-10-2024, passed in bail application number 344/2024, comma 123 koriba. Order is 28-10-2024, passed in IA 329/2024, and 18-01-2025, passed in criminal miscase number 367/2024 and 2/25. There is no reflection in those orders that before granting bail to the petitioner, who is an accused under sections 4/6/8/12/17/21 of the POCSO Act, amongst others, where the trial is also going on, comma, the special court POCSO UPR issued notice to the informant of said Itanagar Women Police Station case number 20/2024. Before proceeding further in this writ petition, we like to peruse the records of Itanagar Women Police Station case number 08/2024, along with the records of BA number 344/2024, criminal miscase number before the letter, with IA number 329/2024, and criminal miscase number 367/2024, numerical endeavor 2/25, wherein the orders there are 28-10-2024, comma 20, just a minute, wherein orders dated 03-10-2024, 28-10-2024, and 18012025 respectively have passed. তারা করে একটা sentence লিখিল। It is also seen the special public prosecutor POCSO who appeared in the matter before the learned special judge POCSO did not point out pertaining to the issuance of requirement of issuance of notice to the informant. All for the records of litigation. Forthwith placed on 7th. Copy of this to register. এটা খালি নোট করে থোৱা।
on 7.
It is to be noted herein that the Honorable Supreme Court, in the case of X versus State of Rajasthan, have held further. In the case of X versus State of Uttar Pradesh, the X versus Rajasthan litigation decided on 27/11/2002. The Honorable Supreme Court in the case of X versus State of Uttar Pradesh decided on 13/12/2024 have held. Moreover, the Register Judicial, by its notification dated notification number 17, issued on 15/03/2024, as well as the corrigendum dated 19/03/2024, specifically provided that in every such bail application / criminal appeal, every such bail application, it shall be mandatory to implead the victim of the guardian of the support person as the case may be. While making such impleadment, identity of the victim shall be properly screened, strictly adhering to the mandate of section 33(7) of the POCSO Act. Upon impleadment of the victim / guardian / support person in the bail application / criminal appeal, bail application as the case may be, formal notice shall be issued to such victim of the guardian of the support person through the investigating officer of the officer in charge of the concerned police station, and it shall be the responsibility of the officers within bracket small s to get the notice served. The notice, next paragraph, issued to the by the same notification number 17, dated 15/03/2024, the Register Judicial, the Guwahati High Court also further clarified that a notice issued to the victim of the guardian of the support person shall also contain a stipulation that in a case he C is unable to engage a counsel of choice, services of free legal aid counsel shall be provided to represent him or her in the proceedings filed before the High Court. It is seen that while issuing those bail orders, the provisions specified in the notification number 17 dated 15/03/2024 and corrected by corrigendum dated 19/03/2024 issued by the Guwahati High Court was not adhered to by the concerned court who issued those bail orders. What you call for the records. List and charge. Next.
The-
May I please, Lordship? Lordship, I am appearing on behalf of Mr. H.K. Das. He is based in Guwahati, Lordship. I could not able to come today, therefore, I would like to pray for adjournment, Lordship.
Yes, who is appearing for the respondents, dear?
Lordship, I have also taken a consent from the other party also.
On the prayer of the council for the petition, list on 6th. 6th of May.
May your lordship. Lordship, in item number 3, pleadings are completed, your lordship. In item number 4, the respondent was supposed to file what affidavit in oppositions.
My lord, at number 4, my lord, we are filing the affidavit in this, my lord, next week, my lord, within a week, my lord.
On 2 occasions, they have already
Hello.
taken
Only-
time.
In WPC 246. Notice in this case was issued
Yes, your lordship.
on 25/06/2024. And parties have already accessed their affidavits. Issue rule. As the respondents have a duly represented, no formal notice need to be issued. List this matter for hearing
Can it be
on
on,
10th of June.
can it be on 20th of May, your lordship? 20?
You can have it on 27th, no issues, but not on 28th.
20, your lordship.
27.
20th of May, 20.
In 28th of May, I don't know, but anyway, it should list for hearing on 28th of May. The interim order passed earlier
In both the
on
cases.
25/06/2024 shall remain in force until further order of the court. In item number
4, your lordship.
4. Notice in this case was issued on 17/12/2024. The respondents are yet to file their affidavits in the matter. Placed on 28/20. In the meanwhile, the respondents still file their affidavit. The interim order passed earlier on 17/12/2024 shall remain in force until further order of the court.
Deeply obliged.
Deeply obliged.
Staff matter, তুমি যোৱা কি দীঘল order কৰিব আছে। Not at all.
Your Lordship, I'm appearing on the behalf of Mr. M. Kato, DSA. Your Lordship, due to a medical emergency, Your Lordship, the DSA has left the court
Notice in this
premises.
case was issued on 04092024. Matter pertains to carrying out of the cadre review of Border Road Engineering Services within bracket civil, comma, an organized Group A service of the General Reserve Engineering Force. The respondents shall file their affidavits on or before 30th May without fail, by serving a copy of the counsel for the petitioner, comma, failing which this writ petition shall proceed ex parte against the respondents. List on 4th of June.
May please, Lordship. My lord, in this case, notice were issued on 17/9/2024. It's almost more than almost 7 months. They have not filed affidavit. Like I have. If it is yes or no, this affidavit should have been filed.
You are appearing for whom, Mr. Kato?
Yes, Your Lordship. For respondent 345, Your Lordship.
3, 4, and 5. But with an observation that if they don't file their affidavit, the case will be taken up for disposal.
Your Lordship, 2 weeks' time may be granted, Your Lordship, to file affidavit. As, the DSA has left the court premises, Your Lordship.
Whether state has filed?
No, Your Lordship, we too need some more time, Your Lordship. At least 3 weeks' time may be granted.
But in that case, can we have a fixed date on 22 May? With an observation that if they don't file, endeavors will be made to dispose of this petition.
Whatever the compensation that was assessed that you have received?
Normal.
Notice in this case was issued on 17/09/2024. Matter pertains to reassessment of compensation, taking into account of the rate of cardamom under the right to fair compensation and transparency in land acquisition, relief and rehabilitation act 2013. Both the state respondents, number 1, 2, 1, 2, as well as the respondents in the Union of India, 3 to 5, shall file their respective affidavits on or before 30/05/2025, serving copy of the same on the counsel for the petitioners. Failing which, this petition shall proceed ex parte against the respondents, adding respondents will be list on 4th of June.
Last question.
Would I say, Lordship?
That's I have gone through the writ petition. It's a very, it requires hardly 1 page affidavit. That's all. To state the facts, you need only 1 page, remaining up to the councils. I have gone through.
May I, Lordship,
In this matter, Lordship, this is just, I have filed this application for disposal of my representation because on the earlier occasion, the Deputy Commissioner concerned has issued notice for a resurvey of my land.
We have seen everything.
Yes.
Yes.
That is why, Lordship,
Okay, heard. Mr. Tapak, not Tapak. You are Mr.
Tapak.
Ah,
Tapak.
Tapak. T. Tapak, Land Council appearing for the petitioners.
Yes.
Ma'am, you are appearing for
I'm for 1, 3, 4, and 5, Your Lordship.
NMST Wangul Land Council and Government Advocate for 1, 3, 4, and 5. For land management, who is
Oh,
appearing?
yes, I'm Your Lordship. 1, 2, 3, 4, and 5.
1 to 5.
Yes, Your Lordship.
The parties have already exchanged their affidavits. The notice in this case was issued on 2011-2024. And parties to these proceedings have already exchanged their affidavits. Issue rule, no formal notice need to be issued as the respondents are duly represented and have filed their affidavits. List for hearing on 26th of May.
Yes, Your Lordship.
My lord, I have received the affidavit in opposition filed by the concerned department. That is respondent number 1 to 3. And the 4 is appeared by the private and they are yet to file.
Lordship, I'm for respondent 4, Lordship. We need 3 weeks time to file the affidavit.
See, yesterday there was a repetition, item number 2 probably. যোৱাকালি এটা দিছিল, repetition আছিল, যোৱাকালি কিছুমান আছিল। যখন 13 আছিল। যোৱাকালি আপোনালোকে ছিল। Coordination council. Item number 1 and 2. Qualification. Please take a minute, sit for a while, just take. Party number. Respondent number. Respondent number 4 আছিল. You appeared in yesterday that matter, no, Mr. Pada appeared. Did he appear?
No, Lordship.
Who appeared? Extension officer, it's a matter of AOP. You appeared, Ms. Gaite? Did you appear? No, because respondent number 4's qualification was challenged, holding that he is not a graduate in technical distance. He was only diploma holder.
Is that Picha's case?
Picha was there, that's right. That's right. But the here what we have seen, they have given the annexes where the signatory list of extension officers are there. So there will be qualifications. I forgot his name, that's why you could have pressed out. Anyway, we'll see to that. You are appearing for whom?
Respondent 4, Lordship, private respondent.
Private respondent, okay, forget it, John. You are appearing for the petitioner?
Yes.
No, respondent number 4 নিব লাগিব। Caveat এখন আছিল, কি নাছিল নেকি? এইটো আছিল, এইটো তোমাৰ এইটো লাগে। Respondent number 4 number, file to any cell. See, relative assessment. For you also, I'm telling you. Here, in this petition, petitioner is the husband and the wife who served in the government for 10 years expired. The respondent number 4, who is claiming she is the daughter of the deceased. The financial status of both the petitioner and the respondent number 4 was considered. And thereafter, the state respondents came to the finding that the respondent number 4 is economically weaker
Right.
compared to the petitioner. That's correct, because the amount that has been received by the petitioner on the date of his wife and the amount which are yet to be received by the family of the respondent number 4 can be seen. That is why we're seeing that it is the relative assessment. Now, whether the court can consider these aspects or not. Apparently, economically, the respondent number 4 is weaker. The respondent number 4 emolument has not yet been paid, whereas the petitioner has been paid the emoluments of his late wife. But there are two things. Petitioner is a male, he can work. He was fully claiming the wife's post, and he was on the basis of the salary of his wife. But he being a male, he is competent enough to work. But only the relative assessment we're talking in. Respondent number 4's family, there is only one minor, rest all are major, including the respondent number 4. Whereas in the petitioner's family, petitioner is no doubt there, but all his 3 children are minor. So this relative assessment of the petitioner and the respondent number 4, whether High Court can look into it. High Court cannot look into it, because now they have considered economically, no doubt the respondent number 4 is much, much weaker than that of the petitioner. Right? So that kind of assessment, when it is made by the state respondents and while granting the post for compassionate appointment. Now, maybe the one court might think that, oh, no, this person is having 3 minor children, he should be considered for compassionate appointment. Whereas the respondent number 4's family, all are major excepting one. But in other ways, it is the respondent number 4 is much, much economically weaker compared to the petition. So in such circumstances, whether the writ court can issue any writ, because it is up to the government to decide. Right? So basically, the respondent's affidavit is very clear. If you have anything to say against the respondent's affidavit, you can say maximum, otherwise you know the outcome. Okay, and there is no stay order also. It's a matter pending since 2023. Might be the respondent number 4 have joined our service on compassionate ground.
Well, then up to that aspect, the government entities respondent number 4 need to inform this honorable court what was the further consequences. And that is there. And so,
Have you appointed the respondent number 4 or not?
so far the affidavit is
Yes, what's
concerned,
your
and that has not been which part.
Sure.
Whether he has been appointed or not, that has not been mentioned. Rather, the statement of the government is that an independent committee may be constituted to ascertain that who is having the
Next case.
this better economic position.
No, that's see, basically I have seen going through all this petition, we found that the case of respondent number 4 is clear cut. Get the information and let us know by Wednesday or Thursday. That's all.
Thursday.
List on 8. Enabling MS K one more, right? P Pangu, always these two mistakes. government advocate. You are additional senior government advocate,
Junior government advocate, Your Lordship.
Arunachal Pradesh. To apprise the court as to whether the respondent authorities for in the Urban Development and Housing Department have appointed the respondent number 4 on compassionate ground or not in terms of its where is the order?
Minute of meeting dated 28/9/22.
No, no. By which order the respondent number 4 was selected?
That is the minute of meeting 28/9/22.
Page number.
Page number in 37 to 39.
By which the respondent number 4 was selected for compassionate appointment under the Dying Harness Scheme on the date of our father. As there is no stay order in force. There is no stay order as the court since 16/5/2023 did not pass any interim order in favor of the petitioner.
But my lord, it was made clear that subject to the outcome.
That will be
only,
subject to the outcome, definitely subject to the outcome. Okay, you get the information
Okay, Lordship. Yes, Your Lordship.
on 8.
Eight.
You want to have it?
All right.
Number 9.
কি নাম ছিল মানুষের? কি মোদি আছিল?
Your Lordship,
Just a minute.
we had the instruction to FIR on
Please take your seats. এই লকালি রিলিজ করুন আছে রিলিজ করুন এটা বলছেন ওটাও কেস আছে এই কেস কেটা কানেক্টেড টার্ম পরবর্তী রিভিউ ঠিক আছে রাইট ওকে তুমি একটু ভালো করে দিবা 10-2 আর 10-9 আৰু এটা আছে 10-2 সগে কি connected case. Yes, you made some submission. Yes, what is your submission? You are appearing for someone.
Yes, Your Lordship, we had been instructed to FIR on behalf of respondent number 7, 9, 10, 11, 13, and 15.
Just a minute.
That is private respondent. What is
7, 9,
10, 11, 13, and 15?
13 to 15.
13 and 15.
13 and 15.
What did will be filing Wakalat Nama?
Okay, definitely. What's your good name?
M. Tasso, Your Lordship.
Nikhilo. Ma'am, you are appearing for?
Your Lordship, this morning we have filed Wakalanama on behalf of respondent number 8.
8.
Yes, Your Lordship. So your lordship, we need some more time to file affidavit.
What's your good name?
B memo, your lordship.
Santu.
Eight.
You are appearing for the petitioner.
Yes, lordship.
What's your good name?
K Basan.
Okay.
Your lordship, we humbly pray that 3 weeks time may be given to file affidavit, your lordship.
Such and such learned counsel appearing for the petitioner. And I'm a strong learned government advocate appearing for the state respondent numbers 1, 2, 3, and 4. 1 to 4. On instruction, Mr. Such and such has entered appearance on behalf of the respondent number 7, 9, 10, 11, 13, and 15.
May I, Your Lordship? I'm for only respondent number 1, Your Lordship.
Only for respondent number 1. लिख दीजिए. No representation on 2, 3, 4. लिख दीजिए. Further, MS Such has entered appearance on instruction has entered appearance on behalf of respondent number 8. Both the councils such are praying for some time to file wakalat number in the matter as well as to file their respective affidavits. Prayer aloud. Respondent number 7, 9, 10, 11, 13, and 15, as well as the respondent number 8, shall file their respective affidavits in this matter on or before 26th of May,
Deeply obliged, your lordship.
list on 28th of May. Await service report on the respondent number 5, 6, 12, and 14. এই তার পাছত লিখিব এমটার appearance পাছত await service report. তার পাছত council appearing for the file affidavit লিখা আছে. Okay.
Deeply obliged.
But in this case also notice was issued on 26/9/2024, almost 7 months ago. Affidavit, no affidavit filed
You are appearing with the page.
for the
Yes,
petition.
Lord.
See, basically, the stay order is in force. You should have done it.
Understand, Lordship, we are awaiting reply from Deputy Commissioner, but then Lordship, we could not ask this before, but only one extra copy has been given. There is 3 departments.
Ask your colleague to serve her a copy by Monday, okay?
Otherwise, this is not the reason for 7 months delay. She could
No,
have
you
just
can understand.
asked me that no extra copies has been. We had filed extra
That is, I
copies.
will not pass any order to that extent, Mr. Pardon. Just ask your colleague to serve her a copy, 3 copies. Ms. Ate, it is an important issue. So,
I understand, Lordship. We have taken steps with regard to the Deputy Commissioner only, Lordship, because we have received office note says they have received only 1 copy, so that they have taken.
but anyway, we grant
Steps
you
taken.
some time to file your affidavit. The stay order is in force. So you file your affidavit by 27th of May.
Lordship,
Let it be slightly
Lordship,
longer.
some more time may be allowed here, Lordship,
See,
because
difficult, we can give you 4 weeks, 5 weeks, 6 weeks, whatever, but we will not file even in 6 weeks.
Lordship,
Yes.
That is the difficulty. After 6
Yes.
weeks, you will not appear, somebody else will appear and say, need some 3 weeks more. That is, some monitoring is required. That is the reason we are asking you. You tell us when you will file. We'll give you the date.
4 weeks. Lordship.
Give us a date by which you will file. We believe Miss Ate, that's all.
No, let it be on 5th June then.
No, let her say on when, because she should be comfortable, but thereafter no time should be granted. But Mr. Patil, through your colleague.
Madam, yes, madam.
Give us a
Yes,
date.
time.
By Monday, you will get the copies.
Yes.
Okay.
Lordship.
Tell us the date now.
Lordship, 5 June is all right.
Who is date?
5th June.
5th June. Okay. On the request of MSG, additional synagogue, list this matter on 9th of June. In the meanwhile, the respondents, number 1 to
No, Lordship, with regard to Deputy Commissioner, Lordship, because we have taken steps already. To other department, we haven't taken steps.
No,
So,
no, that is the reason you are fixing it on that day. In the meanwhile, the respondents. Numbers,
I am all for all the respondents, Lordship.
you will be representing Forest.
Forest also, Lordship.
Yes.
So forest, we
Land-
haven't taken steps.
Doesn't matter,
And the
sufficient.
Land
Deputy
department.
Commissioner definitely have the file. Once you go through the file, it is sufficient. Okay, files are there, affidavits on or before 6th of May. One another.
6th of June.
June,
6th of June. An extra date I have been given, right?
Lordship.
The interim order passed earlier shall remain in force till the next date of listing of the matter.
Obliged, Lordship. Happy break, Smaller.
Lordship.